Okay, let's dive right into this explainer and decode the notoriously dense rules of evidence. We're going to transform them into a tactical playbook to help you survive what is essentially the ultimate legal minefield, the bar exam. Now, if you're reviewing these rules, you already know they can be tricky, layered, and just packed full of exceptions that are incredibly difficult to master. But today, we're bringing order to the chaos and mapping out exactly what you need to know to pass. Here is our roadmap for today: navigating evidence rules, first-hand knowledge, hearsay exceptions, disqualification traps, and we'll wrap things up with the Pemberton and NBN-ZT cases.
All right, Section 1, Navigating Rules 128 to 134.
Okay, I want you to remember this sequence: 4, 4, 54, 6, 48. It's basically your secret mnemonic for the number of sections per rule from 128 right up to 133. As you can see, Rule 130 is the giant here, the most heavily amended, sitting at 54 sections. Rule 128 has 4 sections, 129 has 4, 131 has 6, 132 has 40, and 133 caps it all off with 8. Keeping this numerical structure locked in your head helps you instantly categorize questions during the exam, long before we even zoom into specific provisions.
So the whole point of evidence is essentially building a bridge, right? You're trying to establish that logical link between the evidentiary facts and the ultimate fact in dispute. The factum probandum is your destination. It's the ultimate proposition you absolutely must prove. And the factum probans? Well, that's the material you use to build that bridge, the evidence itself.
Moving on to Section 2, the first-hand knowledge rule.
Let's put you in the shoes of an examiner for a second. When a witness is up on the stand talking about something they didn't personally perceive, you need the absolute precise legal terminology to strike it down. If a witness says something they only heard from someone else, your gut instinct might be to jump up and shout, "Hearsay." But based on the current rules, is that actually the most accurate foundational objection? Actually, you don't just yell, "Hearsay." Instead, you want to invoke the first-hand knowledge rule under Section 22 of Rule 130. This shows the judge that the witness cannot make known a personal perception. A witness can only testify to those facts which they know of their personal knowledge, meaning it has to be derived from their own perception. Pinning your objection exactly on Section 22 shows total mastery of the rules, and it keeps you from getting tangled prematurely in a web of hearsay exceptions.
Next up is Section 3, High-Yield Hearsay Exceptions.
Now, as a general baseline, all extrajudicial statements are considered hearsay, unless they're subjected to cross-examination. But the rules give us 13 specific exceptions. To successfully get a dying declaration admitted as one of these exceptions, you've got to check off all 4 of these requirements. The really crucial detail here is that last one. It is only applicable in specific criminal cases. We're talking homicide, murder, or parricide. It's considered evidence of the highest order simply because of the solemn belief that a person who is about to die is just not going to tell a lie.
Examiners absolutely love testing the difference here. It's a classic point of confusion. A dying declaration requires the actual consciousness of impending death. Res geste, on the other hand, is driven by an undesigned, startling occurrence. Think of a sinking ship. Imagine someone calling you while their boat is literally going down to tell you what's happening. They aren't consciously giving a solemn legal declaration of their impending death, right? They're reacting to a startling incident. That statement is admissible as part of the res geste because the sheer shock of the event strips away the opportunity to fabricate a lie. Now, if a statement doesn't neatly fit into those first 12 exceptions, watch out for this sneaky pitfall, the newly added residual exception. It's essentially the ultimate catch-all. Even if it's not a dying declaration or res geste, if you can prove to the court that the statement is trustworthy, material, highly probative, and serves justice, you might just get it in. Just remember the absolutely crucial procedural trap here. You must give the other side fair warning in advance.
All right, on to Section 4, Testimonial Disqualification Traps.
Under Section 24, we've got 5 core relationships protected by the seal of confidentiality. But listen, the bar exam isn't going to ask you for the general rule. No, they are going to test you on the exact moment those seals break. That's where the real traps lie hidden. Here's a prime example. Consulting a lawyer to commit a future crime, that totally breaks the privilege under the crime-fraud exception. But confessing to a past crime stays absolutely sealed. So if a client tells their lawyer, "Hey, I'm going to shoot someone tomorrow," the lawyer can report it. But if the client says, "I shot someone yesterday, please defend me," that is fully protected by the attorney-client privilege. Knowing that timeline distinction is absolutely essential.
What's really fascinating here is the strict limitation. If the examiner hands you a murder case involving a doctor's testimony, that privilege simply doesn't apply. Zero. It is strictly for civil cases. Also take note that the rules explicitly include psychotherapists and dentists under this umbrella. This ensures that confidential medical disclosures, unhampered by the fear of being publicized on the witness stand, are protected. But again, say it with me, only in civil disputes.
Let's wrap things up with Section 5, the Pemberton and NBN ZTE cases.
To really anchor these rules in reality, let's impartially look at the NBN ZTE investigation. The case of Neri versus the Senate perfectly demonstrated how public officer privilege operates during a legislative inquiry. When summoned by the Senate to testify about conversations involving the president, Neri outright refused, invoking executive privilege. And the Supreme Court ultimately ruled in his favor, reinforcing the strict legal boundaries of what can actually be demanded during a legislative investigation.
Ultimately, the Supreme Court upheld the privilege to guarantee absolute candor among presidential advisors. It protects the deliberative process, showing us the real limits of public disclosure. High-level executives need the freedom to explore alternatives without the constant fear that their private, closed-door deliberations are going to be exposed. This deliberative process privilege ensures that the nation's highest officers can freely debate sensitive policies.
Shifting gears over to the Pemberton case, we see this really dramatic intersection of criminal procedure and the rules of evidence, specifically regarding venue and motions. Following the incident in Olongapo, a private prosecutor acting for the victim's family filed a motion to transfer Pemberton's detention to the local jurisdiction. Now, logically, that sounds pretty sound based on venue, right? But here is exactly where the procedural trap snapped shut. So while the venue itself was jurisdictional, the fatal error here was procedural. It's a harsh reminder that even if you have incredibly strong facts, failing to properly notify the adverse party makes a motion pretty much a mere scrap of paper. Plus, remember that in criminal cases, the prosecution must be under the direct control and supervision of the public prosecutor. So, the private prosecutor's motion was inherently defective because it ignored these fundamental unyielding rules.
So as you review for the bar, you have to ask yourself, can you instantly untangle these rules when the pressure is absolutely on? It's nowhere near enough to just memorize definitions. You have to see the mechanical traps hidden in the exceptions and the procedures. Keep this playbook handy, remember the sharp distinctions we've drawn today, and approach those questions with absolute precision. So knowing what you know now, how quickly will you spot a hearsay disguise on your next exam?